Good evening, I'm Brett Baer. A federal appeals court says it wants answers by Thursday about whether President Obama's attorney general believes the Supreme Court has the authority to overturn a federal law. A direct response to the president's Rose Garden comments about his health care law Monday. Correspondent Shannon Bream is here with this late-breaking story. Good evening, Shannon.
Hi, Brett. Well, today a panel of Republican-appointed judges from the Fifth Circuit heard arguments in a case challenging a provision of the Affordable Care Act. This is something separate from what's pending now before the Supreme Court. A source inside the courtroom tells me that federal Judge Jerry Smith looked directly at the attorney for the Justice Department and asked whether her boss believes unelected judges have the right to strike down federal laws. The judge said he wants a letter directly from Attorney General Eric Holder answering that question on his desk by noon on Thursday.
The burden is on those who would overturn a law like this.
Recognizing the firestorm, his Monday remarks about an unelected group of people overturning the health care law ignited, President Obama made a fresh attempt today to emphasize the notion that the judicial branch should respect the work of the legislative branch in most cases.
I expect the Supreme Court actually to recognize that and to abide by well-established precedents out there.
Mr. Obama's friction with the court is nothing new. Having publicly scolded the justices in his 2010 State of the Union address, it's a posture that seems to closely mirror President Franklin Delano Roosevelt's frustration with the Supreme Court. After the justices issued decisions limiting ambitious government programs he crafted during the 1930s, he threatened to add 6 new seats to the court, packing it with justices who shared his ideology.
I will appoint justices who will not undertake to override the judgment of the Congress on legislative policy.
The court-packing scheme never materialized. It was Roosevelt's successor, President Harry S. Truman, who exhibited the deference more common among U.S. presidents. In 1952, just hours before steelworkers were set to strike across the U.S., Truman nationalized the industry, a fight that went all the way to the Supreme Court. Before the court had ruled, a reporter asked Truman if he would accept the court's decision. He replied, "Of course I would. Of course I would." The reporter continued, "Well, then, as far as you are concerned, the system of checks and balances goes on unimpeded?" Truman replied, "Why, certainly, unimpeded. I have no ambition to be a dictator." Truman ultimately lost that battle. More recently, President George W. Bush also refused to advise the justices as he awaited a ruling regarding the rights of terror suspects being held at Guantanamo Bay.
We will file such court claims once the Supreme Court makes its decision as to whether or not, as to the proper venue for these trials. And we're waiting on our Supreme Court to act.
Bush lost that fight when the Supreme Court struck down the administration's plan to use military commissions to try detainees. In response, Congress then passed the Military Commissions Act of 2006. 2 years later, the Supreme Court threw it out. Since 1789, the court has found more than 150 congressional acts to be unconstitutional. Brett.
More on this topic with the panel and with White House Press Secretary Jay Carney in a bit. Shannon, thank you.